What's up, everybody? And welcome in. It feels like a Monday today. So much going on this morning, but we're excited to be here. Excited to hang out for a little bit. A lot of you had some questions about some of the differences, or I should say, clarifications here in Judge's order for the media for streaming, what we can do and can't do inside the courtroom, what we may see, what we may hear, what we may read in future hearings, and even the trial in Brian Kohberger's case over in Idaho. So we're going to take a look at that order today, go through it, answer your questions. You can leave them in the comment section as we go, and I will get to as many as I can, of course. As usual, a lot of you already sent me questions on Instagram and Twitter/X. I will probably still call it Twitter because I just can't stop. But hit that like button if you guys haven't already. Make sure you subscribe to our page so you can send me what you want to talk about, what you want to read, what you want to hear, so that we can always bring the content that the most people that subscribe to this channel want to hear. So this is the amended order governing the courthouse and courtroom conduct. A while back, we didn't know if there were going to be cameras, if media was going to be allowed in this courtroom because of how it may be affecting Brian Kohberger's rights to a fair trial as a criminal defendant. The judge said there will be cameras, there will be media allowed, but I will control it as the judge. And this is one of the tools in which the court can control the media, the cameras, the streaming, things like that. It is through a court order. So this order governs the courthouse and courtroom conduct and media activities in this case. This order shall supersede any prior order governing courthouse and courtroom conduct. What does that mean? That means regardless of what was said before, regardless of what was in prior orders, that does not matter anymore. This is the order in place. These are the rules people have to abide by. And you're going to see some things in here that are different, changed rules, additional restrictions, additional clarifications. So anything the prior orders may have said is out the window, does not matter anymore. What's in these 5 pages, that's what everybody should go by if they have any questions as to what is or is not allowed in the courtroom for these hearings. The court is mindful of the need to balance, and I love that he did this to start with this paragraph, because we've had motions, we've had hearings, we've had oral arguments about the media's rights and Brian Kohberger's rights and the witnesses and the victims and the prosecutors and everybody's rights. We did a full podcast series on it. If you want to check out Lawyer You Know podcast on everyone's rights during a trial, the trial by media. And we went through each individual person's rights. The judge did the same in the hearings and reading the documents, and he is balancing everybody's rights with this order. That is what he is trying to do, and he sets it out right here in the opening paragraph. The constitutional right of the defendant to a fair hearing, that's the first right, and what we said was potentially most important. Second, the public's right to information in conjunction with the constitutional and statutory rights of the media to attend the proceedings. So the public has a right. Number 3, the court's interest in maintaining order and an environment that permits all participants to focus on their responsibilities without undue distractions. I like it. And number 4, the court's interest in the safety of the public and court personnel and the need to follow all Idaho Supreme Court orders as may be changed or amended from time to time. So the public's interest, any witnesses or interested parties, the courts, the defendant, the media, he's trying to balance it all. And here we go. It is hereby ordered. Courtroom seating and attendance. He's also focusing on the victims' rights here with A, seating for victims' families, counsels, defendant's family, and court personnel. Certain seating may be reserved for counsel, authorized court personnel, the defendant's family, and the victims' families. So if any of the victims want to show up to a hearing, they can have reserved seatings. If you or I want to go, we probably aren't going to get reserved seatings. B, the general public and media seating. The public and members of the media may be permitted in the courtroom as space permits on a first-come, first-served basis. No person may reserve seats. No standing in the courtroom will be allowed. So it's not going to be a zoo. We're not going to have people making a commotion, yelling, standing, affecting the proceedings with what they're doing. It's first-come, first-served for media and public. Whoever's there in time gets to sit. If you're not, maybe they'll have an overflow room or something like that, or you can watch the live stream, but you will not be permitted to come and save seats for all your friends. Seating in front of the bar, meaning the participants basically. No person other than the court personnel designated by the court, the defendant, and counsel and their assistants shall be permitted to sit in front of the bar of the courtroom without specific authorization by the court. So you got to ask before you do something like that. Entry and exit during court proceedings. Spectators, including members of the media and the public, shall be seated before court is in session during any portion of a hearing. No entry or re-entry to the courtroom shall be permitted while court is in session. No movement around the courtroom will be allowed during court proceedings. Now, my guess is there's going to be exceptions if the state or the defense have to send an investigator or paralegal out to go grab something, call somebody, see if the next witness is there. But generally speaking, this is more like, oh, it says spectator. Sorry, it says spectator. So yeah, this is more like media members can't go out to send an email or a tweet and come back in. More on that later, because we don't want the disruptions in the courtroom. That's the point. We don't want anything taken away from what is going on in court, because that's the right the public and the media have. General restrictions and requirements. So again, here are some additional restrictions and some requirements and some clarifications of prior orders. Security screening. All persons entering the courtroom are subject to security screening. No food, beverage, firearm, or other weapons are permitted in the courthouse. All handbags, backpacks, or purses are prohibited in the courtroom. Any personal property items are subject to inspection. Cell phones. Here's the big one to focus on. B. Cell phones are permitted inside the courthouse, but they must be turned off, not in airplane mode, not silenced, not on vibrate, but off and stowed out of view. Now, whether you agree with this or not, or think this is too much of a restriction, what I like about it is in black and white, and there's no misunderstanding. You should not be confused. If anybody sees your cell phone, it's a problem because it should be out of view. If your cell phone rings or buzzes, that's a problem because it should be turned off, and it cannot ring or buzz when it's turned off. He left no gray area with this. Now, I think there are ways to use cell phones respectfully in court. Sometimes people abuse that, so I get where he's coming from, but I do like how he set it out very clearly. During the proceeding and any court recess, while inside the courtroom. So it doesn't matter if they're in session or on recess. If you're inside the courtroom, off and out of view. Cell phones shall not be used. And here he's going to give a different or additional clarification just in case turned off and out of view is not clear enough. Because while it's off and out of view, you also can't, in your purse, hiding it while it's off, which is impossible. You can't do the following: text, email, record, transmit audio, images, or written accounts of the proceedings to platforms such as Facebook, X, formerly Twitter, Instagram, YouTube, blogs, or other similar platforms or websites while inside the courtroom. No live tweeting, no texting people, no emailing people so they can live tweet, no taking pictures and sending them out, no taking video or audio recordings and sending them out to people, no taking audio recordings or pictures to use them later in your blogs, because you cannot use your phone for that while they're turned off and out of view. So that is going to affect some of the way the media can do their job, but there will be a live stream. Take screenshots, be creative, use video from the court's live stream. Cell phones may only be used outside of the courtroom, which you're not going to be able to take pictures of Brian Kohberger if you're outside the courtroom. You're not going to be able to take pictures of any victims or witnesses or anything like that if you're outside the courtroom. So the court will control the types of images and media that's taken inside the courtroom. I like it. Violation of this rule may result in confiscation of the phone by the court, a bailiff, or other court personnel. They can and will take your phone. Now, what will they do with it? How long will they keep it? Who knows? But don't test it, people. Don't violate a court order, because there could be other sanctions for violating court orders. Other electronic devices. Computers, laptops, or other similar devices are permitted in the courtroom. All right, just want to make sure I didn't check my mic before I started, which would have been a real bummer. And other similar devices are permitted in the courtroom for note-taking only and may only be used in a manner that does not interfere with the court proceedings. Cameras and microphones on electronic devices must be disabled while inside the courtroom. So again, he's controlling the media that they can have, but he doesn't want you taking notes on your phone. To me, a big laptop or a computer is more of a disruption than taking notes on your cell phone. So if he's going to allow them to have the laptops open, to me, I would have said no computers or laptops, only phones for note-taking purposes. But I also understand technology in 2024 now that it's easier to hide or sneak stuff on your phone than it is a computer. A lot more capabilities on most phones than computers, and to hide it and do things in secret. So I do understand that as well. But if you want to take notes to send later, you can do it on your computer, not your phone, or of course, the old-fashioned way, by hand. Electronic devices shall not be used to email, chat, record, or transmit audio, images, or written accounts of the proceedings to platforms such as Facebook, X, formerly Twitter, Instagram, YouTube, blogs, or other similar platforms or websites while inside the courtroom. So other similar platforms or websites basically covers everything. So it's including but not limited to. Violation of this rule may result in confiscation of your device by the court, bailiff, or other court personnel. Disruptive behavior. Any activity or behavior which is considered Disruptive by the court will result in removal from the courtroom. Any spectator who creates a visual or auditory disturbance of the court proceeding may be removed from the court and or the building at any time at the discretion of the court security personnel. Maybe means they won't necessarily, but don't have disruptive behavior. They can and will throw you out. Warnings loud and clear, so there shouldn't be any misunderstanding or gray area where somebody is surprised if they get thrown out. Coverage. How are we going to get to see it? Video recording, still photography, audio recording prohibited. No video recording, still photography, or audio recording is permitted by members of the media or the public as ordered by the court in the November 17, 2023 order. A live stream of the proceedings. So this is saying, so you can't do it with your phones or your computers, but you can't do it with cameras either. You can't bring the old Polaroid in and take some pictures. We can't do that. We're checking all the boxes across the board. Can't do that stuff. A live stream of the proceeding will be provided by the court and will be available in real time. That's interesting. Real time, not delayed later, which is different than they did it before, if I'm reading this correctly, on the court's YouTube page found at, write down that YouTube page if you want to follow it. I'm sure there will be streamers streaming it from that YouTube page. We will be doing reactions and recaps from that YouTube page. The media and the public may capture and use the live stream video and audio footage, so we can use it. But we are strictly prohibited from altering the footage in any way, including zooming in on the defendant. Interesting. So how is he going to restrict members of the media from doing that? So like if TMZ wants to zoom in on Kohberger's fly, like how does the court stop that? What court order or sanctions would he throw down? That's interesting. And just in case anybody's wondering, pulling clips, pausing, reacting, and commenting on those is not altering the footage. Live broadcasting, transmitting, or streaming by the media and the public from inside the courtroom is prohibited, but not from outside. We're allowed to stream it. If somebody wants to do that on YouTube, that's permitted. We're outside the courtroom. These prohibitions include during recess in the court proceedings. Again, he's trying to cover all bases. A portion of proceedings that will not be live streamed. The court-operated live stream coverage of the proceedings will not include audio or video of closed hearings, private bench conferences, meaning sidebars. Sometimes we heard some, sometimes we didn't. Sometimes we heard them later. We're not going to hear these. Between the court and counsel, we know what sidebars are at this point, but in case you're new here, when the lawyers object or something needs to be argued outside the presence of a jury or the public or the witness, they will approach the bench, the lawyers and the court will discuss something. The court will then make a decision. We won't hear that private argument. Conferences between the attorneys and the client or conferences among counsel. So yes, we shouldn't hear counsel talking to each other or, of course, Kohberger talking to his counsel. The video and audio recordings may be stopped or paused at any time by order of the court to protect sensitive witnesses, exhibits, members of a trial jury, or for any other reason the court deems necessary pursuant to this rule. So that means if there's a witness that is a victim, is underage, is an undercover officer, informant, whatever, the court can say, you know what, we're stopping the live stream right now. The court always could do that, but he's just making it clear that that can and may be used in this case. Interviews, reporting, and vehicle parking. News conferences, interviews, or reporting is prohibited inside the courtroom or courthouse common areas, meaning the hallways, things like that. News conferences, interviews, or reporting in the courthouse parking lot or on courthouse grounds is allowed as set forth by the Latah County Parking and Media Access Map attached to this order. Any news conferences, interviews, or reporting from the courthouse grounds shall be done in a manner not to impede foot traffic, obstruct access to the courthouse, or interfere with the daily operations of Latah County. Probably not giving tours during the hours the court is open. Media vehicle parking is allowed as set forth in the map. In addition, any interviews, media reporting, or media parking shall be subject to any additional orders by the court. Media inquiries. Media inquiries and communications regarding these matters shall be directed to Nate Popino, the court communications manager for the Idaho Supreme Court, at his email or by phone, or Latah County District Court, ICAR 45 and 49. All other provisions of Idaho Court Administration rules and our 45 and 49 apply, and any authorization under this order may be revoked at any time without prior notice, meaning I can pull cameras. I cannot allow media. I can make sure you don't bring your computers. I can do whatever I want. I can limit seating at any time I want to within my discretion and within my power as the court. So this does not bind me throughout the case, meaning be careful. Don't blow it. I'm giving you something, but don't blow it. I'm giving you an inch. Don't take a mile. Because if you as the media or as spectators or us as the public we here on YouTube discussing this case, don't blow it. Don't do anything that would violate the defendant's rights, the victim's rights, witnesses' rights, the state's rights. Healthy debate, discussion, disagreement, what the evidence is showing, making our arguments, asking our questions, all great, all welcomed, all educational for the most part, mostly educational, I should say. But don't blow it, because just because we have cameras right now does not mean we will have cameras next week, next month, next year, or whenever this trial happens. That's what that's saying. And he does not have to give any prior notice. That might be to the media conglomerates' lawyers. Security, courthouse area security. Security officers may quiet or disperse members of the public or the media so as to not hinder other members of the public, Latah County employees, and court staff from accessing the building, the district court clerk's office, and any other courtrooms or offices in the building. They can always do that, but why not put it in writing? Disruptive behavior, any activity or behavior which is considered disruptive by the court will result in removal. Any spectator who creates a visual or auditory disturbance, I think this is a repeat paragraph, of the court proceedings may be removed from the courtroom and or the building at any time at the discretion of the court security personnel. Violations of this order may be subject. Violations of this order may subject the violator to a charge of contempt. I was wondering if we were going to see this. So he said they could take the cell phone, they could take the computer, but you're also violating the court's order, which means he could hold you in contempt. The clerk of court shall post this order at conspicuous locations within the courthouse and provide copies to all interested parties. And here it is, public. We're looking at it together. Signed on January 5th. And here is the parking and media access map. We'll look at that in a second. But if he charges you with contempt, that opens you up to all sorts of sanctions. So don't violate this court order. So here we go. No media standing in these areas. Here's the public parking. Here's the media parking. Just shows where you can and can't go as a spectator and member of the media. And it was, in fact, attached. So very interesting. What do you think about these new rules and restrictions? What do you think about the court controlling all of this? This could be a precedent. I could see other lawyers filing an order like this saying, this is what I think we should do, Judge, in other cases. We'll see if that happens. But I really want to know your thoughts. Fair, foul, too restrictive, not restrictive enough. I'm sure we'll have comments and opinions all across the board, but I'm interested in the reasoning, why you think the way that you do. And let's keep the discussion going. Let's keep respecting each other, keep giving people grace, keep hoping people can be redeemed and rehabilitated, and look for the best in people, not the worst, and take other people's arguments and disagreements as an opportunity to learn and discuss, regardless of what their motives may be for disagreeing with you. But that's all we got for this episode. Hit that like button on your way out. Appreciate you being here with me. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.